And our next speaker is Murat Sümer. Apologies for my mispronunciation, if that is the case. And you can come. Murat is going to return to the issue of the mass remote control center, which has been discussed by in outline, and he's already given us some kind of advanced indication of the questions that are going to arise or likely to arise. So, Murat, when you are ready.
I'm ready, thank you.
And you can, if you think in terms of 20-25 minutes.
That would be fine. Yes, thank you. Well, good afternoon, ladies and gentlemen. It's a great pleasure to be here. And at the outset, I'd like to thank the organizers for the kind invitation. In my presentation, I will address the mass and remote operation centers. Especially, I will try to look at the UNCLOS and coexistence with the IMO regime. First of all, ladies and gentlemen, IMO traditionally adopted treaties for addressing disasters, some issues, oil spills, etc., like Torrey Canyon issue, even the Titanic for SOLAS before IMO was established. But we also see some other types of treaties, which are called technology-driving treaties. For instance, when MARPOL Annex 1 and 2 were adopted, we didn't have oil separators. They were not commercially available, but yet IMO regulated this, and the same thing is applicable for Ballast Water Management Convention, for anti-fouling systems, and even for emission-related equipments. And we are seeing a similar scenario here. So IMO, instead of being reactive, it has been very much proactive when it came to mass, and as we have seen, as Professor Ringbaum very rightly enlightened us, that we have already a great acquis, which is around 65 pages, which is significant. Some chapters are more mature than the others, but IMO is regulating something which is not yet readily available, at least commercially. Yes, there are trials, there are experiments, there are tests, but IMO is, I think, doing this to prevent future fragmentation of international maritime law. And right now, I think we all agree that this is not some kind of science fiction or futuristic scenario. At least from technological point of view, it is doable. And the question is not whether or if, but how, in which form, and in what shape. Obviously, with the increasing autonomy, we will have less seafarers or less obligations, less duties to be fulfilled on board. And this creates some legal tension, although it is not insurmountable or deal breaker, but still there is some tension because the current regulatory framework is based on human presence. And with the mass, we see that at least they will be relocated to some other location other than on board the vessel. Ladies and gentlemen, IMO derives its mandate from several resources. First of all, 1948 Convention, which gives it a very broad mandate to provide machinery so that states go and discuss the future of shipping. And moreover, some 50 conventions which were adopted under the auspices of the IMO. Similarly, United Nations General Assembly and UN Security Council resolutions, especially regarding maritime piracy issues. But last but not least, UNCLOS itself enhances the mandate of the IMO. And it refers to it as a competent international organization. And it gives a very much broad room for us to interpret UNCLOS when it comes to technical shipping matters, even in UNCLOS Article 94, which seems to be very problematic at first sight. But thanks to paragraph 5 of Article 94, where we have a room to interpret safety of navigation issues and to be in the charge of master and under the command and control of master, 19.4, paragraphs 3 and 4. However, as we will see shortly, this is not the case for 19.4, 1 and 2, which discusses the social and administrative laws. So it doesn't refer to UNCLOS, to IMO. Therefore, we don't have GAIRAs in practice to regulate criminal law aspects. Ladies and gentlemen, first of all, jurisdiction is an attribute of state sovereignty, and it is central to international maritime law because many IMO conventions, in fact, all of the IMO conventions regulates and governs roles according to the being coastal state, being flag state, or being port state. So as a state, once you become party, you need to incorporate these roles to your domestic law according to your jurisdictional duties. And customarily, and in fact also conventionally, because of UNCLOS, but when we look at custom, flag states have exclusive flag state jurisdiction on the high seas. Although UNCLOS recognized the primacy of flag state jurisdiction, nonetheless, it still recognized the coastal state jurisdiction and also port state jurisdiction. In fact, as Prof. Ringbaum noted, we see the evaporation of flag state jurisdiction in time because of the compliance matters, because of the flags of convenience, perhaps, and increasing importance of port state jurisdiction and port state control as a second line of defense for ensuring compliance with international standards. And port state jurisdiction can be indeed very instrumental in the integration of maritime autonomous surface ships, because as we see, because of the further evaporation of flag state jurisdiction, port state jurisdiction can perhaps come into picture even strongly to support the evaporation or to compensate the loss, and which I will try to elaborate shortly. And in fact, after the adoption of UNCLOS, and especially Paris Memorandum and other regional memorandums, we also see an increasing trend for strong port state control. Now, ladies and gentlemen, let's get to nitty-gritty of the remotely controlled ships and their integration. First of all, we don't have much doubt, as we have already established, that these vessels, at least remotely controlled ships, as long as there is someone in the loop, either on board or in the remote operation center, we can classify them as ships. In fact, UNCLOS Article 91 gives a very broad discretion to grant nationality to the states. Therefore, this is a matter of national law. It's not a matter of UNCLOS to classify or characterize a certain structure as a ship or not. However, once a certain structure is registered as a ship, then that state is bound to apply or to exercise effective jurisdiction under Article 94. And here, there seems to be some legal tension. As I said, these are not deal breakers, but especially with Article 94, which I will elaborate shortly. And the classification of a certain structure which can navigate or which can transport things. If a state registered that vessel, it means that these vessels are theoretically, under the UNCLOS framework, should use or can use navigational rights, because navigational rights are not given to particular ships. Navigational rights are given to states. And if a sovereign state is satisfied with a particular structure to be classified as a ship, then under normal circumstances, as international community, we need to respect the sovereign decision as well. But this doesn't necessarily mean, as we will come in a minute, that you will not have discretion to allow those vessels. Of course, there is some issues there, but at least for the high seas, for freedom of navigation, for innocent passage, maybe innocent passage can be a bit more complicated, but for freedom of navigation in the high seas, for sure, they can utilize these rights, and they can expect similar treatment in coastal waters, in the port approach waters, and at the ports as well. But again, this is a very much evolving issue, and until IMO develops some clarification or some guidance, we can see diverging legal positions, diverging practices all around the world, and which is not very much welcome for our line of work for international maritime law, because we are seeking uniformity and compliance all around the world. And another thing, speaking of the nexus between flex states and port states and coastal states, can be the construction, design, equipment, and manning standards. These standards, ladies and gentlemen, are the main regulatory approach of the IMO. And in fact, for instance, to enhance the safety of navigation, SOLAS incorporates these standards. For marine environment protection, MARPOL has CDM standards, and even the states in their capacity, obviously as port states, can come up with CDM standards. When it comes to autonomous ships, according to Article 21 of UNCLOS, for safety of navigation purposes, without impairing the innocent passage, coastal states can adopt CDM standards. However, these standards for safety of navigation, but coastal states cannot adopt these CDM standards as regards the standards for construction, design, equipment, manning of ships. So in practice, what it means, I'm sorry, I confused a bit, but the design or the manning status of ship, while simply just conducting an innocent passage, it cannot be regulated by coastal states. But the situation changes if this vessel decides to come or visit the port of that state. Because as a port state, then you can regulate CDM standards, you can adopt CDM standards, and which means, since CDM standards are not something that you can change just before arriving the port, you need to abide by these rules even in the high seas. So it has some extra effect, some effect beyond the territorial sea, beyond the port area. Therefore, this is important because it can change and affect the shipping. However, if vessels are not happy with these CDM standards, simply they shouldn't visit those ports. But if they decide to visit these ports, then they have to abide by CDM standards. And therefore, ladies and gentlemen, by adopting stringent rules, CDM standards, port states can refuse the entry of mass into their ports. Ladies and gentlemen, mass code defines remote operation center as a distant location from the mass itself. So, and it is already defined. Initially, there was some confusion. There were, for instance, the term remote master was not used for a couple of years, but I'm so happy to observe that now this is an established terminology, and we are using at IMO as remote master, remote operation center, and remote operator likewise. Ladies and gentlemen, when it comes to the location of remote operation center, obviously there are two scenarios. Either it can be on the flag state territory, or it can be on the another state territory. If the remote operation center is located in the flag state territory, I think this is a higher standard than classic shipping now. because right now we don't have the seafarers on the territory of the flag state. In fact, most of the time, ships registered under flags, they don't even call at those ports for years, maybe. But right now, it will be possible and readily available, if things go wrong, to have some people in the remote operations center. However, the situation is a bit different when it comes to the host state or remote operation state. But first of all, I'd like to make the caveat that under the law of the sea regime, we have only 3 different jurisdictional laws. So flag, coastal, and port state jurisdictions. Therefore, IMO, although it has a very broad mandate, cannot come up with a new jurisdiction like host state jurisdiction or remote operation state jurisdiction. That's a no-no zone. We cannot simply trespass that area. And when it comes to a remote operation center, which is located in another state, I think the simple solution, as Prof. Ringbaum noted, could be, if you can't exercise effective jurisdiction in your remote operation center located elsewhere, then as a flag state, you simply don't allow it. But however, this is again a matter of national decision. IMO probably will not be able to say this because under the law of the sea regime, there is nothing which prohibits having some entities associated with the ship in other territories. Even the ship itself is not in the territory of the flag state. So therefore, theoretically speaking, remote operation centers can be located elsewhere. But the nitty-gritty part, the problem is not the safety of navigation issues, not the protection of marine environment issues, not the classic technical issues of the IMO which it deals with, but the administrative laws, the criminal laws, because administrative law and criminal law applies at the territory of the flag state and also on board the vessel, because we treat those vessels as the extension of flag states. But when it comes to remote operation centers, can we treat those centers as the extension of ships? I will come to that in a minute. I think we can. But nonetheless, yes, we can apply safety of navigation regulations, perhaps. But when it comes to administrative things, when it comes to criminal law, as a flag state, how will I go to another state, gather evidence, investigate, or even arrest people? So how will I enforce? So this is very, very problematic. And I don't think this is something that IMO can regulate. It is not within IMO's broad mandate. So this has to be done, again, bilaterally or in a regional format. So the flag state and the host state can come up with certain extradition agreements, certain regulations, creative solutions. But this is something that we will see in time. On the other hand, for instance, we have some interesting example here, ladies and gentlemen, which is Casualty Investigation Code. If you look at Chapter 7 of Casualty Investigation Code, it notes that for marine safety investigation after a collision, by supporting or being involved with a substantially interested state, the flag state will be regarded as fulfilling its obligation under UNCLOS, which is extremely interesting because IMO, through this code, is making a very important observation and guiding us that through these rules, maybe we can have some maneuverability. We can interpret in a broader way. And if MAS code notes or other related codes note that the certain obligation in UNCLOS can be considered as fulfilled, this can be interesting. But right now, this is just an idea. So therefore, ladies and gentlemen, when the remote operation center is located in a place other than the flag state, then we have an overlap of jurisdictions because territorial jurisdiction comes into the picture of the host state, and also flex state jurisdiction because of the mass. But here, ladies and gentlemen, we might have some answer, because in several cases, Saiga, Virginia 2 cases and North Star cases, IUCLOS treated ship as a single entity, single unit, irrespective of whether the crew is coming from different nationalities, whether the ship owner is not on board, whether the interested parties for cargo, they are not on board the vessel. Still, IUCLOS very authoritatively and very strictly noted that ship, according to the modern maritime practices, is a single unit, single entity. And this can perhaps provide some flexibility to us for realizing mass operations. Ladies and gentlemen, on the other hand, the good news is there have been heated debates at IMO, I must say, but majority of the member states tend to think that SOLAS and ISM codes can be used as models for the certification and for the inspection of remote operation centers. And in fact, this will not encroach upon the sovereignty of the host state, because this is a mechanism which is already working, and through recognized organizations, etc., this can be easily done. But however, the committees couldn't make much progress. At least they couldn't come up with authoritative statements as regards Article 91 and 94, but they suffice to note that these will be discussed as the progress is done in the future. I just want, keeping to the time in mind, I will not go into the positive approach, but I just want to note an important negative approach of one member state. Argentine has been very cautious and very vocal about autonomous ships. And for instance, they made a reference during the last committee meetings to the Article 25, which gives rights to the port states to prohibit the innocent passage, and also to have access of mass into their ports. So it is not just smooth. So things might change at the IMO as well. Maybe this is one of the early indications, but up until now, the member states were very positive. They have been very positive, very supportive, and they seem to agree that the ISM model will be working for remote operation centers. Lastly, ladies and gentlemen, in the last part of my presentation, I'd like to touch upon a very important issue, because up until now, we have been focusing on safety of navigation, even sometimes freedom of navigation issues, etc. But we didn't pay perhaps enough attention to have access to ports, because these vessels, yes, it is great that they can navigate technologically and legally, but unless the ports allow them to have access to visit their ports, they will not make any sense for the industry, because ports are the nexus where the ships meet with the land. So therefore, this is an extremely important issue. And according to UNCLOS, ports are on the landward side of the baselines. Therefore, states enjoy full sovereignty in the port areas, and access to ports is not a right, but a privilege. So therefore, port states, if they don't feel comfortable because of safety priorities, environmental priorities, or because of policy issues, they might decline the access for autonomous ships. However, they need to be reasonable, and they shouldn't abuse the right under Article 300, and it shouldn't be discriminatory. And moreover, ladies and gentlemen, maybe not international maritime law, but international trade agreements will give more ground to autonomous ships if their states are parties to certain WTO agreements to expect similar treatments or to have access to ports. And lastly, ladies and gentlemen, I'd like to propose perhaps a solution for skeptic port states. And this can be a compulsory pilotage for autonomous ships. Compulsory pilotage is an interesting subject, and there has been very heated debates in the past because of the Torres Strait PCCA arrangement, and there has been a solution. And traditionally, IMO didn't regulate pilotage because of the strong local reference, because even in a single country, there can be different pilotage regulations. However, considering the sensitivity of the issue and safety of navigation concerns of port states, perhaps in mass code, there can be a regulation to at least to give some freedom, to some guidance to states, to skeptic states, to have compulsory pilotage arrangements for these types of vessels, especially when they are navigating in higher degrees of automation, so that they can safely arrive to port, load or unload their cargo, and safely exit the congested port areas. On that note, I'd like to conclude my presentation here, and I look forward to our discussion. Thank you for your attention.